Good evening. This is a Supreme Court judgment, very interesting judgment uh, under the commercial litigation. Novenco Building and Industry, A stroke S, that is the name of the company, versus Zero Energy Engineering Solutions Private Limited. Facts of the case: Novenco is a Danish company. It's a manufacturer of highly efficient industrial fans. It entered into a dealership agreement with Zero Energy. In violation of the agreement, one of the director of Zero Energy started manufacture of identical industrial fans, deceptively similar in name and appearance. Then Novenco is issued a cease and desist notice in December 2022. Subsequently, it filed a commercial suit in the High Court in June 2024, alleging infringement of its patent and design. Along with the suit, Novenco filed an application seeking exemption from pre-mediation mandated under the section 12A of the uh, Commercial Act. Zero Energy filed an application for rejection of the plaint on the ground that no urgency was involved in the matter and non-compliance with section 12A was fatal to the suit. First, the matter was listed before a single judge. Single judge rejected the plaint filed by Novenco on the following grounds. 1. There was a delay of 6 months from the inspection of the industrial fans at the uh, place of this Zero Energy's subsidiary company. I have not given the full uh, facts of the case just to avoid it. It's all, according to me, it's not necessary. So there was a subsidiary company which was manufacturing it. So an inspection was carried out. That was carried out 6 months back before filing the suit. So the reason is you could have mediated in between that time before filing the suit. Second is cease and desist notice was issued in December 2022. There was adequate time for mediation that you did not do. Novenco. Third is pre-institution mediation is compulsory under section 12A. The recent judgment of Supreme Court was there. It is a must. Whether it is fruitful or not, first you must follow it. So that is the judgment. Based on that, pre-institution mediation is compulsory, so you did not follow it. So they rejected the plaint. Single judge. Then an appeal was filed before the division bench, which was also dismissed. Then Novenco appealed to Supreme Court. Supreme Court perused the earlier judgments, laying down the legal principles for rejection of the plaint. The following principles were called out. Important principles. 1. Section 12A requires pre-institution mediation for commercial suits. Non-compliance would render the plaint defective. So if you don't go for a pre-institution mediation and if you don't comply with it, then naturally the plaint will become defective. 2. Plaintiff can be exempted from complying with the pre-institution mediation only when the plaint and documents clearly show a real need for urgent interim intervention. Third, court must look at the plaint, pleadings, and supporting documents to decide whether the urgent interim relief is genuinely contemplated or not. The court may also look for immediacy of the peril, irreparable harm, risk of losing rights bar assets, statutory timelines, perishable subject matter, or where delay would render eventually relief ineffective. So these are the things which a court may look into to see whether the relief claimed is really urgent or not. 4. A prayer for urgent relief used as a device to skip mediation can be ignored by the court. Otherwise, everybody will say, no, no, we also need um, urgent intervention of the court. So the court has to look into the documents or the nature of the suit. Then, fifth, court is not concerned with the merits of the urgent relief. This is also very, very important. Court is not concerned with the merits of the urgent relief. But if the relief sought seems to be plausibly urgent, from the standpoint of the plaintiff, the court can dispense with the requirement under Section 12A of the Act. So, Commercial Courts Act, they have to see whether it is plausibly urgent. So, these are the five principles culled out from the decisions of the Supreme Court. Then, Supreme Court looked into the matter before it. Subject matter of the suit is continuing infringement of intellectual property. Supreme Court said each act of manufacture, sale, or offer for sale of the infringing product constitutes a fresh wrong and recurring cause of action. It is well settled in law that mere delay in bringing an action does not legalize an infringement, and the same cannot defeat the right of the proprietor to seek injunctive relief against the dishonest user. Supreme Court said no one co-pleaded that Zero Energy has dishonestly appropriated its proprietary designs and patents to manufacture and market identical fans under deceptively similar name. The accompanying material demonstrates that such infringing activity is continuing and causing immediate and irreparable harm to Novenco's business reputation, goodwill, and proprietary rights. Looking from the standpoint of Novenco, each day of continuing infringement aggravates injury to its intellectual property and erodes its market standing. So the urgency therefore is inherent in the nature of the wrong and does not lie in the age of the cause, but in the persistence of the peril. This is also beautifully said. The urgency is inherent in the nature of the wrong and does not lie in the age of the cause, but in the persistence of the peril. The court cannot be unmindful of the fact that intellectual property disputes are not confined to private realm. When imitation masquerades as innovation, it sows confusion among the consumers, taints the marketplace, and diminishes faith in the sanctity of the trade. So, when somebody manufactures duplicates, then it sows confusion among the public. That means there is a public interest element involved. The public interest, therefore, becomes the moral axis upon which the urgency turns. Therefore, the public interest element need to prevent confusion in the market and to protect the consumers from deception further imparts a color of immediacy to the relief sought. Supreme Court said that Novenco's prayer for injunction cannot be characterized as mere camouflage to evade mediation. That it did not accept. It is a real grievance founded on the continuing nature of infringement and irreparable prejudice likely to be caused by the delay. Supreme Court said a court must look beyond time lag and evaluate the substance of the plea for interim protection. The insistence of pre-intuition mediation in a situation of ongoing infringement, in effect, would render the plaintiff remediless, allowing the infringer to continue to profit under the protection of procedural formality. Section 12A is only a procedure. That is what I think Supreme Court is saying. You have to just go for mediation. If it is over, then there is no suit. If it is not over in mediation, then the suit will follow. Section 12A of the Act was not intended to achieve such kind of anomalous result. Then Supreme Court said how the High Court has erred in its approach. High Court erred in construing the test for urgent relief. High Court examined the entitlement to urgent relief based on the merits of the case rather than looking at the urgency from the standpoint of the plaintiff. So, most important is you must see from the standpoint of the plaintiff whether there is a plausible urgency in it or not. That mistake one. Then, High Court has proceeded on the premise that lapse of time between the appellant's discovery of infringement and filing of suit negated the element of urgency. The approach of the High Court is contrary to the principles laid down by Supreme Court. Then the High Court has also failed to take into account that the present action is one of the continuous infringement of intellectual property. So on all these reasonings, High Court has completely erred in saying that you must go for pre-mediation before instituting the suit. That is what High Court said. Supreme Court restored the commercial suit to the file of the High Court again. Thank you very much. Bye.